I will now call the 10:30 docket, which includes one case, State of Kansas v. Thomas R. Gatewood, case number 128-839. Counsel, you may approach.
Good morning, Your Honors. Emily Brandt, Appellate Defender Office, appearing on behalf of Thomas Gatewood, present and ready for argument.
Thank you.
May it please the court, Assistant District Attorney Matt Maloney for the state, present and ready for argument.
Thank you, Mr. Maloney. All right, you may approach Ms. Branch and begin your argument when you're ready. Thank you.
May it please the court, Emily Brandt, Appellate Defender Office, appearing on behalf of Thomas Gatewood. May I please reserve 3 minutes for rebuttal?
You may. Thank you, and it's noted.
Unless this court has questions regarding the 3 fee issues raised in the briefs, I intend to submit those on the briefs and focus today's conversation on the first issue raised, the criminal history score challenge. At sentencing, Thomas objected to
Before you move on to that argument, I will just ask you, would you agree that none of those fee issues resolve the entirety of the appeal? I'm talking about the exception that you're relying on, a pure question of law.
No, I wouldn't agree with that. I know that's what the state brief, but I put in my opening brief why I think that these are pure questions of law. Again, these are just based on statutory construction about whether or not these fees should or could have been imposed. And I think that's a determination that this court is able to make. Again, I think it's a question of law, how much, if any, fees can be imposed. And I don't think in this case, I mean, first on the CAC fees.
But each legal issue resolves the particular fee question.
Yes.
Okay, thanks.
Yes, yes, Your Honor. At sentencing, Thomas objected to the classification of an Oklahoma child abuse conviction being scored as a person felony. Because he objected below, the state still maintains the burden to prove that that conviction was properly classified as a person felony. Thomas submits that the state cannot meet this burden. If we didn't have enough fun talking about Apprendi earlier today, all of this is still sort of rooted in Apprendi, so I guess we're back there. But Kansas has recently, I guess, this court has addressed it twice, once in Bush and once in Daniels, enacted a new criminal history score statute, which includes sort of a laundry list of factors. And if any of those factors must be present, then an out-of-state conviction must be scored as a person felony. The contra to that then is that if any of those factors are not necessarily elements of the out-of-state conviction, then that out-of-state conviction must be scored as a non-person felony. And we would submit today that Oklahoma statute does not require any of the laundry list in E3B, little 1 or little 2, even though little 2 appears to just be B1 subsection D. In Oklahoma, it was as used in this subsection, child abuse means the willful or malicious abuse as defined by paragraph 1.
Will you just talk a little bit slower? I'm sorry.
Oh, so, of course.
Yes,
sure.
thanks.
Child abuse means the willful or malicious abuse as defined in another section, or the act of willfully or maliciously injuring, torturing, or maiming a child under the age of 18. The state has contended that this is a divisible statute. And so there are actually 2 parts here. It's either child abuse defined under a different statute or the act of willfully or maliciously injuring, torturing, or maiming a child. And the state has suggested that they have presented enough evidence that it's clear that Thomas Gatewood was convicted under the or the act of willfully or maliciously injuring, torturing, or maiming a child under the age of 18 years. I don't think that that is correct. I think that even if this court finds that this is a divisible statute, it cannot find that the state has met its burden to prove that Thomas's conviction was under that alternative means of the Oklahoma statute, which is because the state's presentation to the district court included the journal entry of conviction from that Oklahoma conviction, which just labels the crime child abuse by injury. It says nothing more. It doesn't say what elements Thomas pled to. There's nothing in the record that suggests a colloquy between Thomas and the Oklahoma sentencing judge, or a transcript of the plea hearing that might say what elements Thomas pled to that might establish that this fell under the willfully or maliciously injuring portion of the statute. I think this is particularly so because under the as used in this section, child abuse means the willful or malicious abuse as defined in paragraph 1. That portion of the statute, abuse means harm or threatened harm. And harm or threatened harm includes a mental or physical injury. So you can commit child abuse by injury under either of the alternative means of the Oklahoma statute.
Doesn't a child always have to be present to commit, regardless of which subsection we're talking about?
No, Your Honor, I don't believe that that's correct. I put a couple hypotheticals in my opening brief that would suggest that the presence of a child is not required in Oklahoma to commit child abuse, particularly if the abuse is a harm or threatened harm. If it is threatened harm, there doesn't necessarily need to be presence of the child when that threat is made. I think, for example,
Does that mean there was another person present? I mean, there has to be a person present, right? To make a threat.
I think that that is also incorrect given sort of the technological age that we live in and also the non-technological age. Again, I suggested two sort of hypotheticals in my opening brief.
Well, in subsection 2 of 6811, I think it's E3B2, defines presence as presence includes presence by electronic communication.
Yes. And I think that it is an issue of first impression before this court what electronic presence means. I could not find any definition of electronic presence within the Kansas statutes or within Kansas case law. Again, the criminal cases that I could find appeared to reference electronic presence in criminal cases when we're talking about whether or not a criminal defendant is physically in the courtroom for a hearing. I did find lots and lots of states that have defined electronic presence in wills, estates, and trust statutes, which suggests that it's two or more individuals in different locations, but communicating in real time to the same extent as if the individuals were physically present in the same location. Again, I think that would be an appropriate definition of electronic presence. We don't have one. But if you were to use that definition of electronic presence, then it is certainly possible to communicate a threat via, I think, for example, I said Facebook, where a parent will type out a threat that they'll beat their son up if they don't score a touchdown at the football game. Nobody else is present. The parent tweeted that or Facebooked that. Nobody else was around, but then somebody sees it. And we know that that's a threat because in Kansas, we have case law that says if you put a threat on Facebook and somebody sees it, you can be charged with criminal threat. So there's no presence, electronic or otherwise, of another person.
Well, does the journal entry take that off the table, though? I mean, child abuse by injury. So regardless of which version of the offense, we know that injury was an element, arguably. Let's just assume that that's sufficient evidence that it was an actual injury. So if there's not an actual injury, there's no commission of the offense. And it would seem to me that, you know, for an injury to occur, a person must be present.
And again, I think under the Oklahoma statute, that's not true because under the definition for harm or threatened harm, that includes non-accidental physical or mental injury. And we have Oklahoma convictions sustaining child abuse convictions when there was no physical harm done to the child. I believe they were showing the child sexually explicit adult material. So this is a mental injury, and the laundry list that we have in 6811 does not include mental injury. It must be a physical injury. So because we don't know what kind of injury, I don't think the journal entry covers it.
Right. It wouldn't necessarily, I see your point as to not meeting the bodily injury circumstance, but the presence of another during the commission of the offense. And knowing that an offense wouldn't be committed if there wasn't an actual injury, can't we necessarily deduce that the injury element demonstrates that a person necessarily was present, whether it was physical or mental injury?
Again, I don't think that we can because, again, we have this sort of like, I would suppose it could depend on this court's definition of electronic presence. But also I'm thinking, right, like, I think one of the analog to my Facebook post was just, apparently there's a sticky note on the fridge when no one is home that says, if you don't score a touchdown at the football game tonight, when I get home, I'm going to beat you. But let's say it doesn't say that. It says, if you don't score a touchdown at tonight's football game, I'm not going to feed you breakfast, lunch, or dinner for the next 7 days. This sort of like psychological mental torture on a child.
But the child has to see it to sustain that psychological injury,
I would
would you
think,
assume?
yes, but not in the presence of anybody, right? So the parent leaves it on the fridge when no one else is home. Parent works late, so kid gets home from the football game. Before parent gets home, kid sees the thing and is mentally injured. I mean,
Isn't
again,
that an overly technical parsing of presence that really undermines the whole purpose of the person felony idea? I mean, the idea is that there's a victim, that's a person, that's why it's a person felony. And should we consider that?
Your Honor, if it's overly technical, I think that the Sixth Amendment to the United States Constitution requires that we be overly technical about what the elements of the underlying conviction are. And again, if we're all just sort of speculating about what the elements of the underlying conviction are, we're trying to see if we can get it to be a person felony. I also think that's sort of the wrong frame of reference under the way the statute is written, right? If it is possible to commit the crime in a non-person felony way, then under Romanet little 3, it shall be classified as a non-person felony. And I don't bear the burden here. I know that the state relied on Daniels and suggested in Daniels, right? It's a divisible burglary statute. It was possible to commit the burglary in a way that was both person and non-person. And because Daniels bore the burden to prove which of the subsections it was under, Daniels lost. I don't bear the burden here. The state does, because there was an objection down below. And I think because it is theoretically possible to commit the Oklahoma child abuse by statute, child abuse, in a non-person way, it must be classified as a non-person felony because of Romanet little 3.
Even if a person is present? I mean, that doesn't swallow subsection 2, does it? Sub 3 only relates back to 1. Do you agree with that?
I mean, that I don't know. Again, I frankly don't know what the purpose of Romanet little 2 is, because again, it seems to just be the same as Romanet little 1D. So, which again, this is a statute that was asked for because the state didn't like Wetterick, and so now we have this. And maybe it's overly technical, but again, I think it has to be. If we're looking strictly at the elements, I don't think that we can speculate about presence. I mean, what are the elements that Thomas Gatewood pled guilty to? Did he plead to an element that would require a person to be there? I don't think we know the answer to that question. And because we don't know the answer to that question, it must be a person. It must be a non-person felony. Unless this court has any other questions, I'll save my
Any
time.
questions, colleagues? Thank you.
Thank you.
Grant. Good morning, Mr. Maloney.
Morning, Your Honor. May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. Not surprisingly, I disagree with the analysis that counsel engaged in today. As I argued in the brief, when you look at, and I acknowledge that the defense did object below, so yes, the burden was on us, but our position is that we met that because we did present the journal entry from Oklahoma, which showed that he pled to child abuse by injury. Now, when you look at 7115A in the Oklahoma statute, it says that the crime is defined, child abuse means, and it goes on to provide 2 alternatives. One is consistent with 7102B. The second says, or the act of willfully or maliciously injuring, torturing, etc. When you look at Oklahoma case law, as I cited in the brief, their own court has very clearly treated those as 2 separate ways of committing that crime. I cited on page 6 of the brief, Mitchell versus State, and while that case was analyzing a jury instruction issue, its analysis very much makes clear that the definition of abuse found in 7102 B1 is distinct from the crime listed in 7115A. And even when you just read 7102 itself, it says, except as provided by and used in the Oklahoma Child Abuse Reporting and Prevention Act, abuse means what it means in 7102B. So I would argue that the 7115A, the second part of that statute, of that definition, that would be an example of except as otherwise provided by. And so I think when you look at the journal entry that we submitted showing that he pled guilty to child abuse by injury, and then you see that there are those two alternative ways of committing that crime, I struggle to see that there is much realistic doubt or any doubt as to which version that he pled guilty to. You look at one of those, look at 7115, and the word injury only appears in that second alternative. So our position would be that the journal entry did show which version he pled to, that this is a divisible statute. And I know counsel tried to distinguish the Daniels case that I cited by saying that in that case, the state did not, the burden was different because the defendant had not objected. But that doesn't affect the analysis of whether the out-of-state statute is divisible. It would affect whether the state has proven which version somebody pled guilty to or the elements that that person pled guilty to, but it doesn't affect the underlying analysis of whether the statute is divisible. And my position is, excuse me, Your Honor, go ahead.
No, I maybe am jumping to your conclusion, but it seems to me that if we accept your legal premise that there are two separate ways to commit this crime, your argument really turns on whether that journal entry is substantial competent evidence to support the implicit or whatever finding that this is bodily injury, right?
Correct. Yes. As to that first, that would be my first argument, that the journal entry does show that it was under that second way. Yes.
And I guess my question is, in addition to the label child abuse by injury, does the statutory citation in the journal entry have some evidentiary value too? Because it seems to me that the Oklahoma cases, when they're talking about the pattern instructions for the two different versions, they refer to the child abuse by injury by referencing 7115 and refer to the other version always by adding 7102.
Right. I agree, Your Honor. I do think that citation to the statute is relevant here because I think, again, Mitchell, among other cases, does show that the Oklahoma courts treat these as two different, whether you want to say two different crimes or however you want to phrase it, they definitely treat them as two different things. And so I think that the fact that the journal entry includes not only the word by injury, but includes a citation to one of the two statutes, I think eliminates any question as to which he was convicted of. And so I think, yes, that does further strengthen our case, is that it's not just the word injury, but it's the actual citation to the statute itself. And so again, I recognize her argument with respect to Daniels and the burden, but that does not, the burden has no impact on the analysis of whether the statute is divisible. And so for that reason, we think that Daniels is on point with this case, and that just as the Georgia burglary statute created multiple ways of committing that crime, and it was therefore divisible, so too is the Oklahoma statute. So that is our primary argument, that the journal entry here does show which version that he was convicted of, and it's one that is clearly a person crime under 2168-11. Counsel also made various arguments that if we failed to show that it seems to allow that under, in her view, under 7102, that there would be these hypothetical ways to commit that offense that would not fit within any of the definitions in 6811. I would agree, or I would point to some of the questions that this court asked opposing counsel. I do think that her reading of those and the hypotheticals that she gives, I think are overly technical, and I do think that if you're even under the hypotheticals that she gives, and if we're assuming for the sake of argument that we failed to show that he was convicted under the second option there, I still think that those, as this court indicated in its questioning, it does require, those would all still require at some point the child to read the handwritten note or to read the electronic posting. And I think when you're looking at the overarching purpose of this statute, clearly 6811 was passed in response to Wettrich and to try to get us away from some of these situations where we're posing all of these hypotheticals and trying to come up with any creative ways to say, well, there might be a way where this crime could be committed where it wouldn't be a person crime. And I think clearly this statute was drafted to eliminate that type of analysis. And when you're talking about a person crime and a crime in Oklahoma that requires injury to a person, I just think that it would be stretching all logic to suggest that that's a crime that would not fit within any of the parameters of 6811 E3B small I. So for all of those reasons, the state would argue that while the burden was on the state, that we absolutely met it in this case and that we did prove that this offense was properly classified as a person felony.
How do we interpret presence under, well, a couple of the different subsections, whether it's in B1 or B2? Does it require the presence of another, whether the defendant is there or not? Or does it mean defendants committing in the presence? Or is it ambiguous?
Well, it doesn't say that the statute, the language itself does not require the presence of a person and the defendant. It says a person other than the defendant. So it doesn't expressly say that the presence has to be, at the same time and in the exact same location as the defendant. And so I think that under the language of the statute, I think that does allow for a situation where she's saying, well, they write the note when the kid is not home, but the kid comes home later and finds it. At the point that the child finds the note, it's committed in the presence of a person other than the defendant. And so I think, yeah, even under that language and under that hypothetical that she's preventing, I do still think that requires that would fit under that reading of the statute, Your Honor. If there are no other questions, we would respectfully request that the ruling of the district court be affirmed in all regards.
Any other questions, colleagues? Thank you, Mr.
Thank
Malone. Ms. Brandt, you reserve 3 minutes.
May it please the court. I do sort of want to point out that I can understand looking at the Oklahoma case law and reviewing maybe the pattern jury instructions in Oklahoma. Those seem helpful. I don't think that we can do that. I don't think under Mathis and DeCamp and Shepard that this court or any sentencing court can look as quote unquote pattern jury instructions to determine whether or not the journal entry satisfies the person felony elements here, right? If a statute is divisible, then under Mathis, DeCamp, et cetera, we can look at a limited number of other documents to see if we can glean what elements somebody might have pled to. We can look at the complaint. We could look at the plea colloquy between the defendant and the plea judge, or other colloquies between the defendant and the court to determine what elements were pled to. My understanding of Mathis, DeCamp, Shepard is not that we can go looking at pattern jury instructions in Oklahoma and conclusively determine that. I know that the journal entry cites to 715A. What they really meant under the pattern jury instructions, though, is that it's this alternative means in 715A. Because again, 715A encompasses if this is a divisible statute, encompasses both, I believe, a section of the crime that can be committed in a non-person way and the maliciously injuring, torturing, or maiming a child under the age of 18. So I do not think on the face of the Oklahoma journal entry that was presented to the sentencing court that they could conclusively determine which of the alternative means this conviction was under.
I wonder if does that go to the weight of that evidence, that journal entry? As opposed, or are you suggesting that it just has no probative value because, that 7115 could mean one of two things?
Yeah, I think it has no probative value because it could mean one of two things. You would have to look beyond the journal entry to determine which of the two things it means. And if by looking beyond the journal entry, you're looking at pattern jury instructions that weren't given to a jury and found beyond a reasonable doubt because he pled, I don't think a sentencing court or this court can do that in line with the Sixth Amendment. So I don't think that on the face of this journal entry, the state has met its burden to prove beyond a reasonable doubt that this was by injury. I would also suggest that I think that all the parties are sort of struggling with what presence means in these laundry lists, whether or not the presence is necessary or when. I would certainly suggest that the presence needs to occur when the crime occurs. I think that the laundry list invites hypotheticals. I mean,
Well, isn't this if a tree falls in the forest ish question? The crime cannot be committed until another person receives the threat. Right? If someone puts the Post-it note up and the cleaning lady comes through, doesn't read it and takes it off the fridge, there's no crime.
but let's say the cleaning lady does come through and does find the note. So then the crime is, I don't know. Again,
I'm just saying, it strikes me that the crime cannot be completed unless another person is involved. And all of your hypotheticals involve another person being involved.
I respectfully would disagree. I think another person eventually has to be involved, but I don't think a person has to be present for the crime.
Right, you're limiting presence to contemporaneous.
To the crime, yeah.
Well, but again, the crime is not complete.
Contemporaneous to when the defendant is present.
That's your argument.
That's my argument.
They have to be present at the same time.
Which again, I think makes sense because we're talking about like armed robbery, right? You are in front of me and I'm robbing you, or assault. I'm yelling at you.
What in the language of the statute supports your argument that the statute requires simultaneous presence?
I would say like the presence of a person includes physical presence and electronic or telecommunication. I mean, to me, that just suggests to me that we are physically present or electronically present at the same time, I think. And again, we don't have a definition of electronic or telephonic communication. Doesn't appear that we have a definition of presence. For sure, we don't have a definition of this electronic presence. And if you look at the ways the courts have defined electronic presence, they're talking about contemporaneously these things occurring. So I think that presence means both the defendant and the alleged victim, et cetera, are present at the same time. If there's any ambiguity to that, I certainly think that also runs to Thomas's favor. Again, I think the laundry list invites hypotheticals. The state down below picked 3 of these little subsections that thought it fell under. So I created hypotheticals where I think it doesn't fall under that. I think that because the Oklahoma statute could be committed in a non-person way, and we do not know that he was convicted under the alternative means that the state has presented, the out-of-state conviction must be scored as a non-person felony. So this must be remanded for resentencing. And again, I would submit the fees on the brief, but ask that in order to remand those and issue nunc pro tuncs on those would be appropriate as well.
Any further questions, colleagues? Ms. Brandt, thank you for
Thank
your
you.
arguments, and thank you both counsel for your arguments this morning. We will take this matter under advisement.